Good evening, everyone. Good evening to all those who are joining us from India. Good afternoon, good morning to those who are joining us from different parts of the world. I, Akanksha, co-founder, CEO of Accords International, welcome you all on behalf of our entire team, Accords International. And we are here with another fireside chat, Akanksha Fireside Chat, with a very interesting topic that we all have been talking about, mediation advocacy, partnering with the mediator. And for this fireside chat, we have with us AJ Jawad, who is a well-accomplished face in mediation, not just in India, but across the globe. AJ Jawad is an accredited digital dispute resolution specialist with ADR ODR International UK. He is a partner and head of ADR services, KD Lex Chambers, LLP Gurugram, and a senior mediator trainer for Mediation and Conciliation Project Committee, MCPC, of the Supreme Court of India, and the Tamil Nadu Mediation and Conciliation Center, with an experience of more than 15 years. He conducts basic and advanced mediation training and training for trainers for MCPC, NTN, MCC, and civil commercial mediation training courses in universities in the UK and India. He is empaneled as India Specialist Mediator with the Singapore International Mediation Center and the Bombay Chamber of Commerce. Thank you, Jawad, for joining us today. And we look forward to have this amazing chat with you.
Thank you so much, Akanksha. It's so nice to be here and I can see a lot of my friends apart from Sangeeta. I see Bill joining from Belfast. Bill, sorry, you're from Cork, right? I can see Bill here and I see Manish. Thank you so much.
Thank you.
So
All right. Thank you, Akanksha, for introducing Jawad. Thank you, Jawad, for joining us today. Let me introduce myself. I am Upasana Singh. I'm the founder and CEO of Accords International. We will talk about Accords International in a little more detail towards the end of the session. I don't want to delay the starting of our session. I straight away would want Megha to start asking questions from Jawad, for which we are waiting. Just the reason why we are having this very interesting discussion with Jawad is that as all of us who are mediators, we observe that in India, even in court annexed mediations and private mediations, generally we don't find unrepresented parties in the mediation process. There are advocates always accompanying the parties, and it is very important for advocates and mediators to understand each other's relevance in the process. They are definitely not competitors. So it is very important. This topic also needs as much as highlighting as the entire topic of mediation training. So with that little note, we can start with the topic. Megha, could you please start the discussion for today?
Sure. Hello, everyone. I'm extremely excited for this fireside chat with one and only Mr. AJ Jawad, sir. And also, I want to thank Accords International for thinking out of the box and coming up with this important topic on mediation advocacy and art of partnering with the mediator. I feel privileged to have this conversation with you, sir. I myself am a practicing advocate and I am a qualified mediator. And I really look up to the work you have done and your contribution to the field of mediation. So, sir, if you may allow, we may proceed with the questions.
Yeah, I will allow you on one condition, Megha.
Yes, sir.
That you call me Jawad.
All right, I'll try my best.
Yeah.
Okay, so I'm really excited to know when, how, and why did you decide to pursue mediation as a career? And how was the mediation culture and practice at the time you started your practice in comparison to now?
Okay, I just want to quote my friend Bill Holohan, who's here, joined us from Belfast. When I met him in Belfast, he said, after worshipping for 25 years at the satanic altar of litigation, I found the one true religion of mediation. Okay, so there he's showing his hands, thumbs up. So that was his quote. Well, that's exactly what happened to me, Megha. I enrolled as a lawyer way back in 1988. So it's almost 35 years that I've been a lawyer. But I have been a lawyer for only 25 years. So when I discovered mediation, I realized that I had found my true calling. So therefore, I made the switch over. It was deemed to be suicidal at that time. And many of my friends told me that you're committing professional harakiri by doing this. But I just decided to take the plunge. And here I would like to really acknowledge the support that I received from my wife, who, stood by me and said, you do what makes you feel happy, or what makes you feel good. So that was the decision I took. Now, if you ask me why I did this, okay, so I became a lawyer by accident, basically, okay, because I had no such plans at all in my life. I was just floating around like the flotsam and jetsam of the earth. And one of my cousins called me and said, admissions are opening up for the Madras Law College, so why don't you just apply? So for the heck of it, I applied, and I got the admission. I joined the law college. But because after I graduated, because I had nothing else to do, I decided to take up the legal practice. Well, I had a good practice for almost 25 years, but I found that something was missing. I mean, this may sound very pedantic, or it may look as if I'm sermonizing or something, but that's not the case. It really happened with me that way. I found something was missing, and I couldn't really place my finger on it. I felt like a fish out of water, going to the court, arguing cases for clients, and coming back with a result which, even if you win, sometimes your client is not really happy with the result. And somewhere you find that something's missing. And sometimes you keep thinking, did I do the right thing? Is it the right thing to do? I mean, was I representing the right person? I mean, we are not supposed to ask that question as lawyers. But sometimes it does come up. It pricks your conscience a bit when you realize that, okay, this was not the right thing to do. This was going on, and then again, as things happened with me, I also got married by accident. I studied law by accident. So another accident happened, and that accident was when I saw the Tamil Nadu Mediation Conciliation Center board that had come up in a Madras High Court. So that got me a little intrigued, and I said, what is this mediation and conciliation? Let me find out. So I went inside, I made some inquiries, and they said that a training program is coming up, so why don't you join? And that was a time when the founders of the center had to go from chamber to chamber, pleading with lawyers to come and undergo training as mediators. So when I went there, they really lapped it up. And I told my wife, why don't you also come, and why don't we get trained as mediators? Let's see what it is all about. And I underwent the training. And then I realized that, okay, this is what is missing. Okay, so it somehow resonated with me immediately, because I always thought, because of course I was incapable of such profound thought in those days, but when I reflect back on it, and when I try to analyze why I was uncomfortable with the litigation process, I realized that what we have done, actually, the legal system as we follow, which is again, legacy that has been given to us by our colonial masters. We have laws which define what is right and what is wrong, and we have institutions that implement those laws. Now, what is defined as right alone can be agitated before the courts, and if you're able to prove it, you get the relief. But human interaction is not like that. Human conflict is not restricted to just rights and wrongs. It has several facets to it. And those facets don't find a scope for expression when you talk of litigation. So I found that, perhaps that's where mediation fits in, because mediation goes beyond the rights and wrongs and looks at the people who are involved. And what exactly do these people need, and what is it that they really require, and how are they feeling about the whole thing? Because litigation, court is not a place where feelings are respected. Nobody is bothered about how you feel. So this is a place where you really, give respect to people. People are people. Like if Megha is there, it's Megha, it's Upasana, it's Jawad. it's not plaintiff, it's not defendant, it's not respondent, it's not petitioner, it's not PW1 or CW2, whatever you may call them, okay? So that is where I found that it resonated a lot, and I realized that, okay, this is what is missing. And it was a sort of what I call as my eureka moment. Because I was at the mediation center, I did not run out of the bathtub like Archimedes. But in effect, that was the kind of effect it had on me. I realized that, okay, this is it. So I think I should do this. And this is perhaps something that I was really looking for. So that's the short story. I hope I didn't take too long on that.
I completely agree with you on that, that mediation actually appeals to us somehow. So now coming to my next question, we notice that mostly advocates are mediators, especially in court and ex mediations or statutory mediations. So do you think there's any need to bring distinction in these two fields, and we need more mediators from distinct backgrounds as well?
I think, I was preparing to go for a training program, and I got a call from one of my lawyer friends, and he asked me, where are you going? I said, I'm leaving for the airport. And he said, where are you going? I said, I'm going to conduct a training program in Hyderabad. And he asked me, how many people are you going to train? I said, I hope to train 1.3 billion people, which is the population of India. Okay, so I think that should answer your question, because I believe that it cannot be conflict management and conflict resolution. Conflict is something that affects everyone, right? Why should it be within the exclusive preserve of only lawyers and judges to resolve conflict? Why can't people resolve their own conflicts? So why should we not have people from different disciplines, from different professions, who can get trained as mediators and resolve their own conflicts? And if lawyers are listening to this, and if they feel, okay, this guy is conspiring against us, let me assure you, gentlemen and ladies, that's not the case. Because today, statistics, I was reading a Niti Aayog report, which said that almost more than about 80 to 90% of justiciable causes don't come to the courts. So what perhaps lawyers are surviving or thriving or flourishing on is only a fraction of all those disputes out there. So being in a primary position of the port of being the port of first call, where people with problems come to you as a lawyer, I think either as a mediation advocate or as a mediator, perhaps you can play a very important role. But that doesn't mean that we exclude others from coming into this. It doesn't mean that we stop people from mediating their own disputes. I mean, disputes which affect those who are around them. So perhaps HR professionals, maybe chartered accountants, company secretaries, engineers, doctors. So why can't they, why can't they sit there and deal with their own disputes and perhaps come to us when it doesn't work out for them, right?
Completely agree with you, sir. So now I would just ask one of the personal question I actually am very much interested to know about. Do you think that is need of advocates at all in mediation? Like, there are few countries where mediation is only a process between parties and the mediator.
Okay, when you said personal question, I got a little concerned. That's not a personal question, but it's a good question. So do we really need advocates in mediation? Yeah. See, what I found in, we have been doing mostly court and ex mediation so far in India, right? And lawyers play a special role, okay, because as I said earlier, they are the port of first call if you have a problem. So you go to a lawyer and you discuss with the lawyer what to do about it. And lawyers play a very significant role in, because they basically enjoy the trust and confidence of their clients. So what I found in my actual practice as a mediator is that it's much easier to deal with parties if they are accompanied by their lawyers, because one, you as a mediator are a stranger to them initially until they develop the trust and rapport with you. But until then, they need that support from their lawyers to be a part of the process, to sit there. Because in court and ex mediation, what happens is you have gone to court because you could not resolve the dispute. And now the court is suddenly asking you to go to somebody else. So I had this case where I was referred a landlord and tenant dispute. And the landlord just barged into the mediation room, looked very accusingly at me and said, "Why should I come to you? Who are you? What power do you have? Why are you sitting here? And what are you going to do for me? You cannot even decide this. So why should I waste my time with you?" So he was really angry because he was, referred to mediation. I said, "Well, gentlemen, please sit down for a minute and let me ask you a question." I said, "Before you came here, who had the power to decide this dispute?" He said, "The judge." I said, "Well, the judge has taken this power and given it to you and said that there's a person called a mediator who's going to help you to find a solution yourself. So use this power and he will tell you how to use this power. So it's up to you now. You want to use the power, you want to go and give it back to the judge and say that, no, thanks, please use it and resolve my dispute. I don't want to use this power." So he quietly sat down. We went through the mediation and the mediation succeeded. And his lawyer was present throughout the proceedings. Okay. And I have found that lawyers generally cooperate. We always perceive lawyers as people without a conscience. Or, it's very difficult once you become a lawyer. Banks refuse to give you a loan. Landlords refuse to give you a house on rent. Fathers refuse to give their girls in marriage to you. Or for that matter, their boys in marriage to a lady lawyer. So it works both ways. So we have a lot of problems as lawyers. But basically, lawyers are also human beings, right? And they're in a position of trust. So when I got enrolled as a lawyer, my father gifted me with a plaque with a quote of Khalil Gibran, which said, "The greatest trust between man and man." Forgive the gender, statement there. It should have been a gender-neutral statement, but perhaps Khalil Gibran was born at a time when this was not an issue. So he says, "The greatest trust between man and man is the trust of giving counsel." So I had it put up in my office, and I think lawyers have that kind of trust, and they want to do good to their clients. And till date, in the 15 years that I have been a mediator, I have not experienced any difficulty with lawyers. So I welcome lawyers. I feel that lawyers should be there in a mediation if parties feel the need to have them or they're already in the picture. I don't believe in excluding lawyers. I feel they can play a very significant role in guiding their clients towards resolving their problems.
I want to add there, Megha, if you allow me. So I think we can also take the discussion on. So Jawad, what I have observed myself and experienced that in case of unrepresented parties, since mediator is not in a position of giving any advice, because mediator is neither a lawyer nor a counsel nor a therapist sitting there, and you can see that one of the parties, for example, there was this matter where a woman was relinquishing all her interest in a partition dispute, all her interest in favor of her younger son, and she was under the impression that he will keep me safe and I will stay with him at his house, and if he kicks me out, then I will take my share back. So in these positions, mediator is in a very tough spot. Mediator cannot advise. You have to ask intelligent questions to let the woman understand that there might be but had she been with an advocate, accompanied with an advocate would have taken care of her interests there. So I think, again, advocates are very important in the process of mediation. I agree with you.
Yeah.
Thank you, Megha.
Thanks for that, Upasana.
Completely agree with you both. So here I would come up with the next question. That how do you advise mediation advocates practically partner with the mediator to help or aid in the whole process?
Well, that's a very good question, Megha, because see, as lawyers, what are we trained to do? We are trained to go through whatever the client tells us, the so-called facts, right? And we analyze those facts and we see where in the legal framework we can fit those facts so that we can get the kind of relief that a client wants, perhaps, or maybe something that the law permits, right? So now what happens is the focus in a litigation is always on the past. Okay, so when you file your pleadings, you're talking about what has happened. who did what went wrong, who was at fault. So there's a lot of blame game that's going on. So a lot of allegations, counter allegations in the plaint and the written statement or whatever the pleadings that you may file before the court. It's all about the past. When you get into the box, when you get your client into the box, you're asking your client only about the past. And you're trying to prove to the court that my client is right and the other person is wrong, and therefore my client is entitled to a relief. So you operate under a completely different mindset. Okay, your whole psyche, your whole training is only to find out how you can, distinguish between what the law permits and how best you can, get the kind of relief that your client perhaps, whether he deserves it or not, whether how you can get that kind of relief. Now, when you are a mediation advocate, it's like it changes a lot because you start focusing on your client's future. So what is it that my client really needs? So, what needs to be done to ensure that my client gets what he needs, not what he wants, and also the other party, because what you're doing is you're assisting your client in a negotiation, right? So virtually you are becoming a negotiator on behalf of your client. So your whole mindset needs to change there. Your whole thinking needs to change, because you need to now start thinking beyond the positions that you have taken in your pleadings before the court, and start thinking about how to move your client as well as the other party beyond those positions, help them to understand what their interests and needs are, and discuss with the other party how exactly these needs can be met. So your role undergoes a kind of a transformation. Okay, so you're different from a litigation advocate, because in mediation, that is what the mediator is trying to do. And the best thing that you can do is, on the one hand, ensure that your client's interests are protected, and also ensure that you're not only your client, but also the other party do get what they really need to resolve this and to move on with their life and to look at the future. So my feeling is, as a mediation advocate, your interactions with the mediator matter a lot, because your cooperation with the mediator matters a lot. Because the more you're able to help the mediator, the better results you will be getting for your client, right? And instead of, the way you argue a case in the court will be completely different from the way, like how you would confront the lawyer for the other party, will be completely different when you sit in a mediation, because here you're not confronting. Okay, you're not in a competition here, you're collaborating. So from a competing mindset, you need to evolve into a collaborating mindset. So isn't that? So isn't it? So you need to virtually undergo the transformation yourself, and you need to look beyond the paradigms that you have been learned to look, you have been trained to look at. Okay, so what does the law say on this? What is my client entitled to? What is the evidence on record? What are the facts? What is the truth? You move beyond all that and look at something which is very simply your client's interests. So how do I best serve my client's interests? By helping my client to get what he or she really needs. So that is where I think the transformation comes about. Upasana, you want to say something?
Yeah, so I get a little perplexed when I think about how that transition can happen, because generally advocates, they are in the morning, they are in the courtroom, they have their book filled with dates, and they just give 45 minutes for a mediation setting. It's like they are moving in and out from a courtroom. And then how can that mindset change? I think we should add that in our curriculum. This entire mediation advocacy should be added in the curriculum at law school level. Otherwise,
absolutely right.
Yeah, because it's very
no, I think no, not only that, Upasana. I feel the whole law school curriculum needs to undergo a transformation. It needs to undergo a change, because all we are teaching our lawyers are to be gladiators. So they are only gladiators who are going and fighting in the arena, called the courts. So how do we change them into becoming negotiators? How do we change them into becoming people who can collaborate with your opposite party and do what is best for your client? So how do you bring about this transformation? And that, I think, requires a lot of rethinking and unlearning, as Sangeeta has pointed out in the chat. There's a lot of unlearning that is needed. So, in fact, I think this video has become quite a controversial video when it's from Madhya Pradesh, and the High Court judge calls it as a mediation. And you can see what was happening over there. I mean, I don't blame the learned judge for the simple reason, because the learned judge ought not to have called it as mediation. He could have simply said that, okay, this is my opinion and this is what you need to be doing, instead of calling it as mediation. But then you see the kind of mindset that operates over there, the kind of thinking that goes into, because I know best and this is what I advise you to do, and therefore you better do it. It is that mindset that needs to undergo a transformation. See, it is that mindset that makes us lawyers a very pompous group of individuals. Pomposity goes with our profession. I mean, when we speak, when we are, holding court, it's all about us, right? So
I agree.
I mean, I'm a lawyer. Basically, I have been a lawyer for more than 35 years now. I've been a lawyer, so I know how it operates, okay, how the mind works. So the moment you see a problem, so the moment you see a problem, you know what the solution is. And you don't really care whose problem it is and what that person thinks about it. You're ready with your advice. Let me just share a small experience with you, like how, actually litigation escalates conflict. When I was a lawyer, okay, many years back, I mean, I was a junior at that time. I mean, I had just been about 8 or 9 years into my practice. And I was referred a divorce case by somebody known to me. And this lady came to me. And she told me what all happened with her. And I made my notes. And I told her, ma'am, can you come after 2 days? I'll have the petition for divorce ready. And she came after 2 days and I gave her the petition. She read it and she started crying inconsolably. I said, what happened? Have I said something wrong there? I said, sir, you have put it so eloquently. I didn't know I had suffered so much. Okay, so you see what actually was I doing there? See, as a lawyer, I was doing my duty, because from the fact she told me, it was not enough to make out a case for cruelty as a ground for divorce. So she gave me a bowl of rice, and I added a lot of masala to that, and I made it into biryani, right? Because that is what I can serve to the court. So now imagine when the husband reads this, and he goes to his lawyer and look at what all my wife has told about me. So what did he do? And the lawyer sits down and says, don't worry, we'll prepare an equally strong reply. And there comes the reply. So the conflict escalates.
Yes.
Yeah. So this is the kind of thinking that we need to move beyond. We need to think beyond this. And we need to, really think of, Mihir says that was your lawyer skills. Yes, lawyer skills. And that's what needs to be changed, actually. Those skills need to be unlearned a little. And we need to start thinking about what is best in our client's interests, not just what relief we can get our client in the court. And I always, there was can I just continue with that answer a little bit more, Upasana, if you don't mind? Do you have the time?
Oh, no, I never mind.
Okay, so there was a recent article on this mediation bill that was coming. The president of the Madras High Court Advocates Association had written an article saying this mandatory mediation will be preventing people from, or will be against the fundamental principles of justice. Now, what is this justice we are talking about? I wrote a reply to that. It was published in Live Law. And my question is, what is your definition of justice? Is it justice only if the court delivers a judgment? Is it not justice if you and I sit down and talk to each other and find a solution to our problems? Is it not better justice than what the court delivers? Because we know what's our problem, right? And we are solving it ourselves with the help of somebody who's just facilitating our conversation. And what is wrong with that? How does it detract from the fact that, in fact, I feel that mediation means access to justice. It will improve access to justice. So justice as delivered by the courts, as Amartya Sen says, there is a difference between the concept of niti and the concept of nyaya. Institutionalized justice is not complete justice. The concept of niti is institutionalized justice, but nyaya goes beyond that. Nyaya is justice that I feel, I can realize that yes, justice has been done to me. Now, who's better? Who can do that better than me myself? Right?
True.
So why not I get empowered and do justice to myself? So that's a question I just want to put to the audience for, chewing over.
Oh yeah.
I
Please go ahead, Akanksha.
Jawad, you have so much beautifully put this. So I think recently Justice Chandrachud also mentioned the same thing. That law
exactly,
is not justice. What we deliver in court, it is just the word of law. It is not just always.
Yeah.
So what we do in mediation, in court, we are just putting an end to that conflict without going into the details why that conflict arose. But in mediation, we are resolving why it happened so that it does not repeat itself in future.
Correct.
So in true sense, justice is what we do when we sit together and discuss what happened and why it happened and why it should not happen again.
True. Yeah.
Just to add
See,
there,
justice according, sorry. Yeah, go ahead.
just one line, Jawad, just to add that I think that is why in our constitution, if we read Article 142, I always tell this to my students, the conventional justice delivery system dictates and demands the usage of the phrase complete justice in our constitution. I always ask, I asked my professor in Indian Law Institute that why are we using complete justice? Isn't justice in itself complete? So that is why are we prefixing it? That is the, I think that is the vacuum created by the conventional justice delivery system. When we get a decision, we are not satisfied. It is not complete.
Yeah. Because it can't be for the simple reason that because two people's opinion is substituted by a third person's opinion just because he's sitting on a dais. Okay, and that opinion is taken to be the right one, and you're not happy with it, you go to somebody who's higher than that person. And then you go to somebody who's higher than that person. And that person says, okay, this is right. And then you have to accept it as right or wrong because you have no choice in the matter. Right? So how do you call that as justice? It's something I don't understand. It's justice according to, it is the application of law. Okay? It's just the application of law.
I totally agree with that.
So,
I may be wrong in this. It's just my view. I'm sorry. Yeah, go ahead.
Okay. So as you just talked about the mindset of advocates who are mediators, I would throw a quick question on which I seek your opinion that what do you think that the art of advocacy and prior knowledge of law helps a mediator or makes it worse? Like there is an irresistible urge of giving legal advices to parties that you will not get enough money in the court, your case is weak, you must settle here, this is the best, this seems the best for you. So such interference and judgments are not really allowed by a mediator, but sometimes we see it because it's somewhere in the habit of a advocate or a judge.
That's a very good question again, Megha. I don't want to comment on anybody else, but let me tell you my own experience. Okay, it took quite a big struggle on my part to stop myself from telling people what I think about their case. It was quite a struggle because you get trained for 3 years in law school and then 25 years of practice. You keep telling people all the time what they should be doing and what is right and what is wrong. It's very difficult to unlearn that. It doesn't come so easily. And we all end up doing the same thing. Therefore, what I believe is that whether you're a lawyer or whoever you might be, you need to have the process expertise. Okay, you need to believe in the process, you need to learn the process, and you need to know how far you can go. Okay, so that becomes very important for us. So unless and until you're consciously restraining yourself from doing what you have been trained to do for years together. Now, that is the reason why I decided to give up my litigation practice. Though it meant, a severe, impact on my earnings and all that, I decided to do that because I found that I simply can't sit in the court, I can't stand up there and I can't argue for 2 hours and 3 hours, and then suddenly wear a different hat and come and sit there and mediate and expect to do what exactly I'm not supposed to do as a lawyer. Okay. It was becoming impossible for me and it was giving me sleepless nights. So I thought, what the hell? Come on, let me take that chance because I believe in this. Okay, let me do this. This makes me happy. Let me do this. Let me stop that. So therefore, I took the call and I decided to give it up and I came totally into mediation for the simple reason because I simply could not, I was finding it very difficult to unlearn that advisory part. So as mediators, we are taught you cannot argue, you cannot advise, you cannot analyze, you cannot minimize. And which is what exactly you do as a lawyer, right? When your client comes to you, you analyze the case, you advise your client, you argue with your client first before you argue in the court as to what can be put there and what cannot be put in black and white. What kind of documents you need to file before the court, what would not be admissible. You argue with your client. You tell your client that, look, this cannot be done, right? And then you minimize. And your client says, I'm very upset with my brother. And you say, well, that doesn't matter. Court is not concerned about how angry you were with your brother. Court is only concerned about how much share you are entitled to as per your personal law. So what I call an acronym as ARM, those who speak Hindi will know ARM is a mango. Everybody loves mangoes, but you're not supposed to do that in mediation. You're not supposed to analyze, you're not supposed to argue, you're not supposed to advise, you're not supposed to minimize. And all these things you do as a lawyer. So it is a process of unlearning. And I'm really surprised. I really admire those people who still practice as lawyers and who still come and do mediations and do without advising the parties. But what I find is invariably when you observe a mediation being done by a lawyer, with great respect to all the lawyers who are mediators, you do switch into that role at some point of time or the other. Because you just can't stop doing it. So unless you watch out for it, unless you're very conscious that, okay, now I'm slipping into an advisory role and I'm not a lawyer here, I'm a mediator here, my role is different. I'm expected to do something completely different here, so let me not do it.
And considering the bulk of matters being handled by mediators in India, just because of the sheer fact that there are so many people waiting for you to just hear them, it's very difficult to do that in and out, from being a lawyer to a mediator, to a mediator. So it's, I completely agree with you that it needs a lot of training, lot of reflection, lot of introspection to be able to do that. And
no, in fact, we have a judge, Justice Bharat Chakravarti, who was a mediator before. And he's a brilliant person and very creative in all these things. And he put up a mirror on our mediation center. And in all our training programs, we used to tell the lawyers whom we have trained, we'll tell them that when you go for the mediation, just go stand in front of the mirror. Imagine you're removing the hat of a lawyer. And pick up the imaginary hat of a mediator and wear it and tell yourself, I'm not a lawyer, I'm a mediator. And then go for the mediation.
There was a TED talk, I think, which became really controversial later, but then it was fake it till you make it. This was Jude. She's from, I think, Princeton and then Harvard. So she's a researcher in behavioral sciences. And she was talking about the posture, how your posture can make you believe and make you feel confident and depressed at some time. So she had an accident, and after that she was entering her academic life again at Princeton after a year or something. So she told herself that I will appear confident, I will look confident, I'll sit like this, I'll be. So all her non-verbal communication was being done through her body, and she was like faking it till you make it. So I think that is also a good exercise.
It works. It really works. It really works. It used to work for me. Like every time I would go to the mediation room, I would always stand outside a little, breathe deeply, take a few deep breaths and tell myself that, look, your job is not to advise, your job is not to analyze. You just go there and just listen to those people. Listen to them, that's all. Okay, listen to them and see, how you can help them to understand what the problem is.
Okay, so as we already talked about that there is complete different skill set required by mediation advocates while they come for mediation. So what, according to you, are the must-have qualities for mediation advocates, which are not usually seen in litigation, but they should have when they come for the mediation?
Okay, I think one of the first qualities would perhaps be thinking beyond your own pocket and thinking of your client's best interests. That would be one. Number two would be, first of all, listen to your client. Okay. Don't tell your client what he or she should be thinking or what he or she should be doing. Listen to what they really need. Okay, what their real interests are. Go beyond their positions, try to explore what is actually driving the conflict. Okay. So you need to learn the skill of listening. I mean, virtually everything that a mediator needs to learn, I think a mediation advocate also needs to learn. Because when you're going to be helping the mediator, when you're going to be working with the mediator to resolve your client's problems, you need to be thinking like a mediator. You can't be thinking like a lawyer. You can't have an adversarial approach to to your client's mediation, the way you would approach the matter in the court. So you need to have that complete training where you know what are positions, what are interests, what are needs, what are listening skills, how do you communicate, how do you listen patiently, how do you look beyond those positions and try to explore those interests. So all those skills, I think you need to learn basically, because that is why I feel that whether you practice as a mediator or you don't practice as a mediator, mediation training definitely helps you. Okay, because it helps you to understand, because I just completed the training in Hyderabad and I have had many of my the delegates telling me that it has transformed us. So you do undergo a transformation because you start looking beyond yourself. So what do we do basically? We, as husbands, as wives, as parents, as brothers and sisters, as friends, do we even listen to what others are talking about? However close they might be, however dear they might be to you, do you even listen to them? You're always, even as they are talking, you're preparing your answer. Okay, you're not listening to what they're trying to say. You may perhaps listen to the words, but you're not listening to the feelings that go behind those words. You don't try to go beyond that and explore what exactly is making them say that, making them do that. I had a conversation with a very good friend of mine a couple of days back. And she actually called me saying that I want a therapist because my husband and I are reaching a point of no return. Then I said, okay, fine, if you want to see a therapist, but would you like to discuss it? And she started talking. And all I did was listen. And I asked her a few questions and she realized that, okay, my husband has given me space, but I'm not giving him that space. So that came from her mouth. I didn't tell her anything. Okay. So how much are we listening to people? I personally, I believe that mediation training, a 40-hour or 60-hour training, is not sufficient to make you a mediator, but it at least sets you on that path. You realize there is so much to life than just what you think or what you believe. Okay, there's something beyond your own biases, your own prejudices. At least you are able to realize that, okay, I'm a person who has some bias. I'm a person with prejudices and I have these qualities that are lacking in me. I think that's the first step you take, right, towards evolving as a human being.
Jawad,
so that's why I said I want to train 1.3 billion people as mediators. I don't want all of them to be mediators. I will lose my, No, I'm just joking.
I don't think so. I think it'll create a bigger market to enter for, for everybody to enter.
Yes.
Yeah.
Exactly.
Jawad, with your permission, Megha, with your permission, could I just discuss a bit about the 60-hour training that we are going to do, and you are the trainer in that, and Accords International, and come back to the questions later with the participants. So if you allow me to share my screen. Yeah, thank you, Jawad. So
please go ahead.
So I'm introducing the training here because we just discussed that the curriculum should be altered, and somebody should recheck the curriculum that our law students are going through right now. So I have been an academician myself for almost 2 years, and I have taught alternative dispute resolution as a subject in IB University and Delhi University. So the kind of the manner in which we are teaching law students alternative dispute resolution is something where we are not talking about mediation at all. So that is why, let me just share my screen for everybody to. Is my screen visible?
Yes, it is.
All right, thank you. Is it on the slideshow mode, Megha?
Yes, Upasana, it is.
All right. So as we all know, our organization is Accords International, and we work in the field of conflict resolution. Other than mediation, we also work with restorative justice, and we are passionate about discovering innovative techniques in mediation and restorative justice for widening their scope as a mechanism of conflict resolution. So me and Akanksha, you have already met. She introduced Jawad to all of you. I am Upasana Singh. Both of us, we came together, we founded this organization, and this is something that about what we're really passionate. Then Numan didn't want me to share his picture. He shared the picture at a later stage, which I could not incorporate in the slides. But this is our team. We have students, professionals working with us, and we make a point that we don't work with people who are only from law background. So many of our team members are from economics background, political science background. Then these are the advisors who are working with Accords International. We are communicating on a monthly or a 2 monthly basis. We're telling them what we are doing, and we are getting appreciation from their end. So Dr. Cheryl Picard is a dear friend. Ken Cloak has shown a lot of enthusiasm in what Accords International is doing. Mr. Aman Hingorani, everybody knows Mr. Aman Hingorani. Barry is a dear friend, and he's a mediator based in South Africa. Then other than that, Sangeeta Mehrotra, she's there with us in the meeting. She's also one of the advisors with Accords International. John Sturrock, everybody knows John Sturrock. Then our experts. People who are working specifically in a niche area are joining Accords International as experts. So Floyd, Jerry, Yazid, they are restorative justice experts based in USA. Espin is a sports law advocate and a mediator based in Switzerland. Victor is a JAMS fellow mediator, and he specializes in international mediations. Then Chittu Nagarajan is the one who introduced India to online dispute resolution. I'm very thankful to our experts who have joined us in our vision. Then, as I already told you, we believe in our motto is listen, empathize, and resolve. I want to officially thank Sangeeta Mehrotra here for helping us in finalizing the motto here. So thank you, Sangeeta, for giving us the resolve bit of it. Then our mission is to equip professionals, judges, policymakers, and civil society members with the tools required to nurture creative techniques of conflict resolution. That is why we are innovating with restorative justice and mediation and combining these two. And we are working really hard. If you will look on our page, we have a calendar put up for the coming 2 months, and we have curated a list of a few very interesting events that we would be doing at Accords International in different fields. So there are 3 initiatives which we are working on. these are research initiatives, these are awareness initiatives which we are working on with different organizations based in India and abroad. So Project Cyber Ed, it talks about how to find out a restorative solution for online harms. We recently did a training program with restorative in the area of restorative justice and cyberbullying, and it was a successful 10-hour training. Then Project Mediate Early, I will talk in detail about it in the next slide. Project Samekya is headed by Akanksha. She is doing her PhD from Jamia Media in restorative justice. And we are promoting restorative practices even outside the conventional field of criminal justice delivery system. Restorative practices can be introduced in workplace environment. They can be introduced in a school environment to help people de-escalate their conflicts in an effective manner. Then I would request people who are not speaking to please mute yourselves. Thank you. Coming to Project Mediate Early. Why did we start Project Mediate Early? So as I've already told you that I have been a law professor and I have taught ADR. Akanksha has been a law professor herself. So there was a team of neutrals which came together under Records International, and there was a BCI notification. I think everybody knows about the notification which made mediation and conciliation training mandatory for law students. And I was very surprised to know that there are around 1900 law schools in India. And every law school, I think, has around 2500 students. And God knows how many mediators we have. I think if we do the math, we don't even have one mediator for 100 students. So this is the project that we started for students and young professionals to get trained in mediation right at the beginning of their career. So I remember me and Jawad, we were discussing this, that why is it required for an advocate to wait for 7 to 8 years to get trained by a court-annexed mediation committee? So why not just in the beginning itself? So, and it is just like Jawad has discussed here, that it is not the legal background that is required to become a mediator. So, and Accords International stands for that. You don't need to be a lawyer or a retired judge to be a mediator. Then we are launching a 60-hour accredited learning program in mediation in collaboration with Mediation Academy, South Africa. And it is accredited by ADR Register Global Network Group, Amsterdam. So this is there on our social media pages. You can know more about it. Let me just quickly talk about it is a 6-day learning program, and as you can see on your screen, so we have named the days as laying the foundation. Let's get started. We're talking about the mediation principles. We're talking about the mediation landscape, process of mediation. And we are focusing in this program, we are focusing a lot on the practical knowledge involved in mediation and the techniques. For example, day 2 is entirely dedicated to opening statement and rehearsals. Then we also have communication, non-verbal and verbal languages. Then we have around 20 case studies that will be completed in the span of 6 days, 60 hours. That would include 45 contact hours. Then these are the skills that you would learn after completing the training. Trust building, active listening, time management, communication techniques, restorative practices. Restorative practices is a unique feature. We are having a session on how to include restorative practices in your, as a mediator in your practice. And these are our faculty members. You can see the brochure. We will share the brochure we have already shared the brochure on our social media pages. You can follow us. Accords International is there on LinkedIn, Facebook, YouTube, and Instagram. Jawad is also one of the faculties. I am so grateful that he's on board with us. It gives, I think I started listening to Jawad when I entered the profession, when I started understanding what mediation is. So I think from a very personal note, Jawad, thank you for taking that difficult decision and just transitioning yourself from a lawyer to a mediator. And I can assure that the next generation can say that they are standing on the shoulders of giants when they are successful mediators, having you starting, having you taken those difficult steps in your career. Thank you for that. And why should you train with us? I think so ours is the only course audited by ADR Register, GNG, Amsterdam. We so there's an exposure to restorative practices throughout our training. Our cohort is international and our experts will be international. Then we will have a very small cohort, around 20 students, not more than that. So that gives a lot of personal and individual attention from coaches to every participant. Our course will be role plays oriented, simulation activities will be there. Then we really want professors and assistant professors to join the program and be able to conduct similar programs in their organization and institute. Then we believe in improving with feedback. So just like how coaches and supervisors are giving their feedback to the participants, the program will get improved with the feedback given by delegates, participants also. So peer review is an art which one should learn. You should be able to review your peers without being critical and criticizing them. And you should be able to take that review without feeling humiliated. So I think that is one thing which I feel is very important in today's time when we are talking with students and young professionals. So the entire training will be recorded, it will be virtual, and there will be digital learning content given to all the delegates. And these are our ecosystem partners, and these are the relevant dates. If you want to take a screenshot, you can take a screenshot. And early bird registration closes on August 18, 2022. So thank you for listening to me. I'm stopping my screen share here. Yeah.
Congratulations, Upasana. That's really amazing.
I think, Jawad, it's not because you are there in the session I'm saying this, but I owe a lot to you in terms of how you're just being a flawless mediator is that is how you do flawlessly. So thank you for being you.
I think you're being very kind to me. I don't know whether I deserve that.
No,
Thank you anyway. Thanks a lot.
So,
Thank you so much.
So coming back to the session, Jawad, if you have 5 more minutes, there are few questions mentioned in the chat box and comments. I would want to read them to you.
Yeah, I have quite a lot of time on my hands. Don't worry. As long as people don't get bored.
No, I don't think so. I don't think so, Jawad, because you know what, in fireside chats, generally, we have a very interactive chat box, but
Yeah.
this kind of interaction happened when we had a fireside chat with Ken Cloak and Michael Lang. So that was, and having an interactive chat box is something that is very, it gives you a very happy feeling. Let me.
And they are the real giants. They are the real giants. We are in fact standing on their shoulders.
True. So Wala here, Wala, if you're there in the meeting, do you want to unmute yourself and ask the question, or do I go ahead and ask the question? So Wala is a regular who has been joining our sessions regularly. So she says that, how do you handle a situation where after the parties settle, but before they sign the terms of settlement, counsel to the claimant and the claimant come up with new demand and request that new terms be added to the settlement agreement, and the defendant refuse? The matter is a walk-in, not court referral. So how do you handle a situation like that?
Yeah, I think I would blame myself for that situation if I was the mediator, because basically it means that I have not listened to the concerns of the parties fully, and I have not really understood what their interests are. I have allowed something to be unsaid over there, and that has cropped up at the last minute. But if I feel I have done my job and it's something that the parties are just taking a position or just to block a settlement, it means that the process has to continue then, if they are willing. So it means I have to still continue with the process and discuss with them what is the basis of this and what makes them ask for these things. So what is the story behind their claims? So go into that and see whether I can bring about some understanding between them that they are able to reach a settlement. So it means that I simply, go through the whole process again, provided parties are willing and provided they're willing to pay my bill.
That is important.
Yeah.
I think Vala just unmuted herself. Do you want to follow up on that, Vala?
Okay. Thank you, Jawad, for your contribution. Make good sense. But the second arm of your contribution is we actually concluded the mediation online and the parties agreed on terms. But I had this caucus meeting with just both parties. That is the claimant and the defender. And they agreed on terms, which was now read out at the general meetings, and they both agreed, But after the meeting, the lawyer to the, because we have a WhatsApp chat group for parties, for online mediation, so they can exchange information. I was told that the counsel to the claimant was not happy. That is the mediation advocate. He was not happy that I had a private caucus meeting with just the parties. And thereafter, they were supposed to come into the office to sign the terms of settlement. But the counsel to the claimant, who was not happy, came up with a long written, letter complaining that his party does not agree with those terms. They want new terms. And then the defender said, no, this is what was agreed, that is in the draft settlement terms. So I said, okay, let them come back so that we can talk about it. But they refused to come. If it was a court-referred matter, maybe we would have tried one more. If they don't come, we'll return the file back to court. But it's a walk-in, and we don't know. I just wondering what to do. They don't come. How can I listen to them to find out, hear their story, again?
Yeah, the problem, Wala, is that, the mediation being a consensual process, unless and until both sides are there before you, there's nothing much that you can do.
Yes,
and see, one of the factors that, from what you have told me, if I have heard you correctly, I think one of the issues here was that the counsel was not part of the private session that you had with this client.
I believe so, yes.
Yes, I think that would have, I don't know whether you're aware of what is called a SCARF. David Rock came out with a paper based on neuroscience. He said there are 5 social domains where we feel a threat or reward response, which is status, certainty, autonomy, relatedness, and fairness. So I think the counsel felt threatened, perhaps, because you had a private session excluding the counsel. So
I told him the mediation is a party-driven affair, I had a session with both the councils and their parties. Then I decided to have with just the party, because I got to realize that the council was, difficult, trying to make things difficult,
See, now the thing is, the problem here is that when counsel are involved in the mediation process, it's better to involve them throughout, no matter how difficult they are. Because if you exclude them at any point of time, they are not going to allow they're not going to allow their clients to resolve, to reach a resolution. And it all depends on how much the clients trust the counsel and how much they are willing to abide by the counsel's advice. So that is
Okay.
beyond the control of the mediator.
All right.
So
Jawad,
I would say that if, sorry, Upasana, just 1 minute. So I would say that wherever counsel are involved, please involve them in the process from the start till the end. Because
Okay.
they can always sabotage the whole process if they feel that they've been excluded. Just give me 1 minute. Huh?
Sorry.
So just because we are almost 5 minutes over our scheduled 1 hour, Prajwal, I'll get back to you. I'll come to you just the moment Jawad is back. So if there is any question, you can connect with us on Accords International on LinkedIn. Our page is Accords International. You can connect with Jawad also, and you can send us an email on info@accordsinternational.org. So Jawad is back. I think Jawad, if your time allows, just one last question from Prajwal.
Yeah, please go ahead, Upasana. I have no problem at all. I'm sitting in Hyderabad in my hotel room doing nothing. So I'm more concerned about your time, about the time of the people who are here.
Good evening, sir. It's great to connect with
good
you
evening,
again. This is my second session of yours in last 2 weeks. So
Okay,
my question is that what should ideally be the style that should be followed in India by a mediator? Should it be facilitative or should it be evaluative? Because in my opinion, if a mediator practices facilitative style more, the parties may sometimes think that what was the effort that mediator has put in, or what is the opinion of the mediator that he has given. So I'd like to know your opinion on that.
Okay, that's a very, very relevant question in the Indian context. There's a point of view which says that a mediator should be like a fly on the wall. And a really good mediation is one where the parties walk out of the mediation believing that they have resolved it and the mediator did nothing. Okay, only make sure that you collect your fees before that. But I'm always coming back to the issue of fees. But that's a real mediation, because see, one of the cardinal principles of mediation is that you have a problem, you solve it yourself. So what the mediator basically does is empower the parties. Okay, or I would rather not call them parties, that sounds very legalese. So I would call them as participants. So empower the participants to engage in a conversation and to find their own solutions. So all you're doing is you're facilitating. You're listening to them, you're asking questions, you're encouraging them to look at different perspectives, you're encouraging them to look at each other's perspective and try to reach an understanding. You're helping them to understand that they need not look at each other as the problem, that the problem is something separate, that both of them need to work towards resolving, that the problem is common to them. So this is the job of the mediator. So if you're able to do it effectively, for all you know, you might end up with the parties not even saying thank you to you, because they feel that they have found the solution. And I believe that that is a really good mediation, and you're a really good mediator if you're able to achieve that, right? But it doesn't happen that way. Parties do realize that you have played a very subtle role in helping them to, reach that stage. So they really appreciate that. And the fact that, you have listened to them, you have understood what they are going through, you have given respect to their emotions, you have validated their emotions, okay, and you have understood them, and you have empathized with them, and you have helped them to reach a stage where they are able to think beyond what they feel and to come to a conclusion, right? So that's what they do. And many of my mediator friends argue that in India, knowing the kind of culture that we have a high context culture where there's a lot of emphasis on hierarchies. And there's the belief that unless there's an imprimatur of the court or some authority on a settlement agreement, people don't feel happy about it. I don't believe that. I don't believe that because we have been conditioned to think that way. I believe that perhaps maybe in my generation that culture still exists, but not in your generation. I think your generation is quite capable of thinking for yourself. I don't think you depend on your parents to take decisions for you. I don't think you really have that kind of awe and respect for authority. You do respect your elders, but doesn't mean that you disrespect them. But you don't feel bound to listen to them. You don't feel really bound that you should listen to them the way we used to. Okay, so I actually welcome that kind of change, because I welcome that independent thinking ability that the youth have today, and I hope it becomes much more common. And I think we have a bright future for mediation here in India. And I feel that the facilitative method of mediation is the best method, because when you are being evaluative, again, you're substituting your judgment for the judgment of the parties. You're telling them what to do. And then it becomes, again, like any other dispute resolution process. So as a mediator, what you should do is you should empower the party.
Thank you, sir.
I think I agree to that, Jawad. And I was reading a paper on intergenerational mediation and how in Canada, US, senior citizens are getting into the process of mediation and taking help from the process of mediation. And in India, when I was thinking about it, it was a qualitative research in how it is difficult to apply restorative justice and mediation practices in the matters of senior citizens and old age people, because in India particularly, there is a lot of dependence on the younger generation when you get into that age bracket. Now, for a mediation process or an RJ process to become successful, you need that kind of empowerment as an individual to take that decision and saying that, no, I don't want to go the conventional course. I want to go the ADR course, the actual dispute resolution course. So I think that qualitative research was very important, and it should be done in Indian context also. So I agree with you that independence of individuals is and empowerment is required. Mihir wants to ask a question. Mihir, you can unmute yourself and.
Hi, Mihir.
Hi, Jawad.
We can't see you. Oh, yeah. Okay.
Yeah, sorry, I had my camera messed up. Thank you, Upasana, for allowing me to ask the question. So, Jawad, as you know, the Rajya Sabha Standing Committee submitted its report on the mediation bill. And one of their comments is about how the pre-litigation mandatory mediation would actually cause delays and would act as a tool in the hands of litigants who want to delay the cases. So, although I don't agree with this, I just would wanted to understand if you have any comment on this comment of theirs.
See, I have also written an article on this fear of mandatory mediation. It's reported in Live Law here. I don't know whether you read that. See, I don't think that mandatory mediation is bad, because I always equate that with the the old adage that you take the horse to the water. Now, in our country, there's a lack of awareness basically about mediation. So essentially what you're doing is you're telling the parties that, look, here is an option for you. Try it. If it doesn't work out, you can always come back to court. And you're not compelling the parties to go through the whole process of mediation. All they need to do is to, have 1 or 2 sittings at the most. And this model has been very successful in countries like Italy. And today, UK is also introducing mandatory mediation. I think Bill will be able to enlighten us more on that. Of course, it's going to be for small claims which are £10,000 less or less than that. But nevertheless, mandatory mediation is something that I think we should have on the statute, because that will simply create that awareness in the minds of people. Then here is an option. Because in my experience in court annexed mediation, where 89 Supreme Court has said is mandatory, Section 89 is mandatory. You have to refer cases to mediation. Now, I found that people come to the mediation room and they tell me that, look, we are not interested. We don't know why we have been sent here. Then I tell them that, okay, just give me 5 minutes of your time. Let me explain what this process is all about, and then I leave it to you to take the call. And they sit and they listen to what the process is all about, and they say, okay, let's try it. What's the harm in it? and they go ahead with the mediation. So that's exactly what mandatory mediation is going to do. But on the recommendation of the committee, I'm inclined to agree with the committee for the simple reason that today we don't have the infrastructure for that. If mediation is made mandatory, where are the mediators? Where are the institutions? We don't have them. So I think it has to be something which is done gradually, and perhaps we will reach a stage where people will start, opting for mediation as the port of first call before they choose any other alternate dispute resolution mechanism. So that is where people like Upasana, Megha, you, Prajwal, all of you are going to play a very significant role, because by spreading the mediation movement and carrying the message forward. So I don't know how long people like me can continue to do this work, because we are on the wrong side of 60 now. So.
Well, Jawad, if we add our ages together, that would still not be the age that Ram Jethmalani retired at. So I think we are pretty good
exactly. Shape. Yeah. No, I'm just being modest, Meher. I'm just being modest. I believe I'm still 30. Yeah.
Of course. You look like it.
Okay. Sometimes I might be fishing for compliments also. We don't know.
So I think, Jawad, I just want to say that anybody who wants to continue the discussion, I think we are here for another 5 minutes, maybe. And if people want to, we are already 16 minutes over the time, and I apologize for that. So, or if there is there is no other question that needs to be discussed with Jawad, then we can, with your permission, Jawad, we can end it for today and keep few points for the next discussion. All right.
Yeah, sure, Upasana, no problem.
Mr. Nama, I'm sorry if I'm pronouncing your name incorrectly, sir. So Mr. Nama Varapu he wants to ask a question. If others want to leave the meeting, then you're free to leave anytime, because it's already 17 minutes over the time. Yes, sir, please. I'm unmuting you.
Yeah, his name is actually Srinivas Sharma.
Sure. All right.
Okay.
Yes,
good evening, all of you, sir. Good evening, all of you. I'm not. Are you hearing?
Yes, we can hear you.
Sir, I'm not putting any question to you, but when you said that I'm 60 and I may not be able to continue in this, and others you are giving a room for it. But in fact, I want to remind you, because we had a talk also. I'm 66. I'm started now, and you can continue it with more vigor, more energies, more. Because after 6 days, we'll be again becoming young. Becoming young.
Yeah.
Already have shared my opinion with you. Regarding, I am starting the program from the root level. That is the village level program I'm taking up. Unless the litigant public are more getting awareness about the mediation process, it would be very difficult to continue the process here in Indian circumstances. Right. So if the litigant people are being they got awareness, naturally they will pressurize the advocates to think about the mediation process. At the early stage of the Legal Service Authority Act, it was came into existence. The Lok Adalat system was opposed by the tooth and nail by the entire legal fraternity. I think I remember well, the Bar Council of India itself passed an unanimous resolution to boycott the Lok Adalats, because the people were feeling at that time that it is causing the professional loss to us.
Yes.
But ultimately, everybody is taking part in it. So the first who had, because the important thing is the people got awareness that the Lok Adalat system, we are getting a good result. So when they started, they are asking the advocates, so why don't we try in the Lok Adalat, sir? So like that, we have to create awareness first at the stage of the root, the litigant public at the village level, at the root levels, village levels, ward levels. And the legal awareness program on the mediation particularly, it should be spread up not at the urban areas, but at the root level of the villages.
True, sir.
When we start it at village level, at the in association with the DLSs, District Legal Service
Yes,
Authorities, it
Yeah,
will
yeah.
have more impact because
Yeah.
they have got the authority. People will come to a meeting and we can enlighten on the mediation process. And
Yes.
naturally, when you are giving an open explanation to them, people definitely they will come, sir. So
Definitely.
I hope that you will again regain your energies of your 60s or 17th after 60, because I got it already by 66. Okay,
So-
I want to share with you only this aspect, sir. I'm not
So-
having
Sure,
any
sir.
special-
Sure. Thank you.
Okay, thank you for giving me this opportunity.
Thank you.
Thank you.
Thank you.
So
Thank you.
so this is for your information also, Jawad, and everybody in the meeting.
I will
and
just
right.
that you're insisting.
Yeah. So all right.
Sorry, I had a second question. Can Jawad quickly help me or anybody?
Yeah, sure.
Yeah, please go ahead.
Yeah,
Sure.
it's
sure.
actually in the chat. I would you like to what are the recent developments in commercial mediation
In India?
generally, in India, anywhere?
No, in India, I can tell you this, that we have a Commercial Courts Act, a law which created a separate set of courts called the commercial courts, where virtually every dispute which was of a commercial nature would be sent to that court for being decided. Now, that act was amended sometime, I think it was in 2016, when they added section 12A to that, where they said that pre-institutional mediation is mandatory. So they said that before you go to the court, you have to go for mediation and you have to show the proof that you have gone for mediation. But unfortunately, that act created two loopholes. One, it said that if you need an urgent interim order, you need not go for mediation, you can come directly to the court. That was one, which the new mediation bill is trying to plug that by saying that if you need an urgent interim order, you can come to the court, get the interim order, and then go back to mediation. That they're trying to plug that, but we hope they will be able to do it. The other loophole was that if the defendant does not respond, there cannot be a mediation. Now here, I feel that in countries like UK, I think some bill might be able to enlighten us of that. I think there are some either even if the party is successful before the court, they are not awarded costs if they had refused mediation unreasonably. So my feeling is some kind of costs are imposed on a defendant who unreasonably refuses to go for mediation or respond to the invitation to mediation. I think that would help to perhaps motivate parties to go for mediation before they go to the court. Now that is one development. Of course, the other development is the Mediation Act that we are all eagerly awaiting. Hopefully that will come as soon as possible. So these are the two developments that I can think of right now in India. And one of the most significant developments all over the world has been, it's rather ironic that we have to thank the pandemic for this, that we are all sitting today on a digital platform and we are talking to each other. And I was able to do a lot of mediations online, and I found them to be quite efficiently working. And I found that it was much easier to, in fact, organize the meetings and to, hold these sessions because parties were very comfortable sitting in the comfort of in their own zone of comfort and, talking and resolving matters. So that is one very significant development that has happened very recently. Abroad, I think there are a lot of things happening. The Singapore Convention is one of the biggest developments because for cross-border mediation, something like the New York Convention was, the need was acutely felt to have a convention of a similar nature. So Singapore Convention is there now. It is the answer for what New York Convention has done for arbitration. We hope that Singapore Convention will do for mediation. So that's it. I think, in most of the countries, they're realizing, like Italy has got the opt-out model where it's mandatory to attend at least one session of mediation before you go to the court. UK is now bringing about mandatory mediation. So these are some of the developments that have happened.
Thank you very much. What about cross-border commercial cross-border commercial mediation? Do you want to talk about it a little bit, please?
Yeah, that is where the Singapore Convention plays a significant role, Wala. But I think cross-border mediation is happening in a lot of places. One of the drawbacks of that was the implementation of the mediated settlement agreement. And that is where the Singapore Convention steps in and says that if you want to implement a mediated settlement agreement, you can't do it if the country is a signatory to the convention. And I think recently UK has signed the convention and ratified it. And once the Mediation Act comes, we were one of the first signatories. India was one of the first signatories. But the ratification has been delayed significantly because of the absence of a statute on mediation. That's one of the requirements of the Singapore Convention. So if once the act is in place and the Singapore Convention is ratified, I think it will be easy for businesses or other companies to implement the mediated settlement agreements in India, if supposing they reach some settlement in any other country, which is that's something we can look forward to, and that might increase the popularity of mediation also. Hopefully,
and that can make us the hub for mediation, at least commercial mediation, and I hopefully hopefully. Yeah. So,
if it is not monopolized by certain sections of
if at all. So that is the hope, and I think so. I was just talking about another event that we are organizing on August 12th, Jawad. That is mediation and young minds. Now, starting from where you left, as in you feel young and you're touching 60 and being on the dangerous side of 60. So with that event, we are also promoting the idea that young does not mean being young in age. Even if you're 60 and you're starting as a mediator, then you are a young mediator. Then that you can join, and you can have newer ideas to start as a young mediator at 60 also. So I think that is the beauty of mediation. You don't need that particular age to enter the profession and start.
Yes.
So I think it has so many good points that we can keep on going about mediation, Jawad. But I think we have hit 8, and I think now it's time to say goodbye. Although I think I want to take this conversation ahead, but I think we have to say goodbye now. And I really want to thank you, Jawad, for joining us. Before I say official thank you, do you want to say something? And then I'll thank you.
No, I should be thanking you, Upasana, for this opportunity to meet with all these interesting people and to express my views, however right or wrong they might have been. But it's a good, really good opportunity to meet everyone and to discuss all these things. So thank you so much, and thank you for all the work that you and your team are doing for the cause of mediation. I call myself a mediation fanatic. So, so I'm quite an extremist when it comes to my belief in mediation.
I might join the club soon.
Yeah.
Thank you for joining us today, Jawad. And
thank you.
I know I'm repeating myself, but our generation is taking inspiration from the great work done by your generation, although it's not a much of a gap between the two generations. But thank you for showing us the path, and with the hope to have a better mediation landscape in India and making India mediation hub. I think we can say goodbye to each other today, and you can always connect with us on LinkedIn. Thank you everybody for joining us. Thank you, Jawad.
Thank you everyone. Thank you so much.
Thank you everyone.
Bye-bye.
Thank you. Bye.
Thank you. And I will join you on August 12th. I've sent a notice. I will join
thank you.
Okay.
Sure. Thank you so much.
Wow.
Thank you, Bill. Bill, we didn't get to hear you at all.
Not a bad thing when you don't hear from me.
Upasana, Bill
Yeah.
is somebody whom you should be in touch with.
All right.
Yeah, he's got a terrific sense of humor.
Perfect.
And he's from a part of Ireland called Cork. And the rest is not Cork, okay? The rest of Ireland is not Cork, simply that. So, and he's simply brilliant. And when I was in Belfast, when I met him, he kept us in splits throughout the time, okay? So a person with a terrific sense of humor. Please do get in touch with him. He's on LinkedIn.
Definitely.
And yeah.
I'm gonna stalk you, Bill. I'm reaching out to you on LinkedIn.
Oh, you'll really enjoy stalking him. Let me promise. I can promise you that you'll enjoy.
Thank you. Thank you, Jawad. Thank you.
Thank you. Thank you. Thank you.
Yeah.
Take care. Bye
Good
bye.
night. Bye. Take care. Bye.
Good night.
Thank
Good
you,
night.
sir. Yeah. Thank you. Bye.
Thank you. Thank you, Megha. Thank you, Akanksha.
Thank you. So I'm ending the meeting for all. Thank you. Good night to everybody. Bye-bye.
Thank you, ma'am.